So, what happens when you break a major environmental rule before you've even asked for permission? Can you just get approval after the fact? Well, that's the huge question at the center of a major policy debate right now, and today we're going to get to the bottom of what's really at stake.
All right, here's how we're going to break it all down. First up, we'll talk about the golden rule, getting that environmental clearance or EC first. Then we'll get into a really controversial exception that's stirring things up. After that, we'll look at the very real risks of bending these rules. And finally, we'll talk about how the system could actually be made stronger.
Okay, so to really understand what's going on, we have to start with the golden rule. It's a really simple idea that's supposed to be the foundation for every major project in India, the principle of prevention. Now, the whole system is built on this one core concept, prior environmental clearance, or EC for short. Basically, it's a mandatory green light from the government that you have to get before a single shovel even thinks about hitting the ground. The goal is super simple. Figure out the environmental impact before any potential damage is done.
And listen, this isn't just a friendly suggestion or some kind of best practice. No, this is a strict legal requirement. It's all rooted in the Environment Protection Act of 1986, and it's been backed up again and again over the years. The law is designed to be proactive, not reactive. That's the whole point.
You know, the best way to think about it is like getting a permit to build a house. You absolutely have to get that permit before you start building. You can't just build a skyscraper and then ask for forgiveness, right? The system is supposed to work exactly the same way. But this is where that nice, clear principle starts to get, well, a little murky. A super controversial exception has popped up, and it's all about something called post-facto clearance, which means getting approval after you've already broken the rule.
And this slide really highlights the central conflict here. On one side, you have the actual rule, prior EC, which is all about prevention. On the other side, you've got this exception, post-facto EC, which is remedial. It's basically trying to clean up the mess after a violation has already happened.
So this leads to the most obvious question, right? If the entire point of the law is prevention, why in the world would the system ever allow for a cure after the damage is done? It sounds like a giant loophole, doesn't it? Well, the answer is pretty complicated. It's all tied up in a series of court rulings that have kind of gone back and forth. For years, the court said post-facto clearance was a no-go. But just recently, the Supreme Court actually reversed a stay on these approvals, creating what it called a narrow space for these exceptions to exist. So why the change of heart? The court's thinking wasn't to just throw out the EC first rule. Instead, it was to allow for what they call regularisation in very, very rare cases. We're talking about a project where so much money and resources have already been invested that tearing it down is just not practical. The idea is to let it go ahead, but hit it with some serious fines as a penalty. But this is where things get really risky. What happens when this narrow exception starts looking more and more like a regular shortcut? This is where we get into the real dangers of bending the rules, and why this whole debate is so important. Here's the most crucial point. You can't unring a bell. A post-facto approval can slap on a fine, sure, or it can order some half-hearted mitigation measures. But it can never do what a prior review is designed to do, which is to prevent that cumulative, long-term environmental damage from happening in the first place. And if you let this become the new normal, it creates a dangerous domino effect. It completely undermines environmental planning, it makes it impossible to assess long-term impacts, it destroys the credibility of the regulators, and maybe worst of all, it totally breaks the public's trust in the system. So what's the way forward here? If we have to live with these exceptions, how can the system handle them without just opening up a massive loophole for every other project? Let's take a look at how to actually strengthen the system. It looks like there's a pretty clear four-step plan. First, you've got to be really strict about past violations. Second, make the whole process totally transparent so everyone can see what's happening. Third, beef up the monitoring to catch these violations early. And fourth, and this is the big one, you have to constantly reinforce the message that getting clearance first is the only real way to do things. When you boil it all down, it comes to this. Giving a green light after a project is already built just completely undermines the entire system. Yeah, the courts might allow for a few rare exceptions, but these post-facto approvals are a huge risk. They cause long-term environmental damage, and they shatter public trust. The takeaway is simple. Prevention has to be the rule, not permission after the fact. And all of this leaves us with one final big question to think about.
If rules can just be rewritten after they've been broken, well, are they really rules at all?